Yes, thank you.
Thank you, my Lord. I will continue for some minutes, not too long, with what is essentially issue 1, and then turn to issue 2. But if at any stage, as I indicated before the short adjournment, if the Lordships wish to hear about the practical situation, legal situation in Nigeria, I'm happy to deal with that, but unless I'm asked to, I shall not do that. So we have the background now. We know what the Supreme Court in Riel was trying to clarify, patch up if one wants. There is then the question of what does Riel mean, both in terms of what is stated there and what should be the position. And as I answered in the question posed to me by my Lord Legate, we certainly say that this court is not constrained by anything in Riel to adopt and to endorse and adopt the approach which was stated in the Court of Appeal as to the discretion, the parameters and shape, nature of that discretion, which was described in very general terms in Riel. And we would urge that conclusion in this case generally.
You're saying the Court of Appeal decision is consistent with Riel, are you?
Yes, I am.
Is that because you adopt their distinction between the judge deciding of her own motion and the parties? Or do you say, irrespective of that, it's consistent?
Both, my Lord. So we take both approaches. So we say that obviously both can't be maintained as a matter of logic. It can't be. I think it can't be. It's not. We say that it is right that in Riel the question was on the facts directed at the issue of whether a judge acting sua sponte changed their mind. And on the facts, what the discretion would be there, and we say it was valid for the Court of Appeal to draw that to its own attention.
So in Riel, the judge changed her mind after having various points drawn to her attention by counsel that she was invited to justify. That's the own motion side of the line.
Yes.
Where does the boundary come?
When an application is made, my Lord.
So as long as you don't make an application, it's fine. You can just write to the judge, can you, saying, please take these considerations into account. But once you issue the application notice, it's a different situation.
Yes, well, I mean, obviously an application can be, in substance, an application rather than the issuing of an application notice, but in broad terms, my Lord understands the submission. Yes, that's right. There is.
Why is that? Why is that a relevant difference?
Because, well, as I indicated in the written case, we need to unpick what we mean by the word and application, or words and application for reconsideration. What in fact one is asking when one makes an application is one asking the judge to, firstly, reconsider it, and secondly, vary it. When it is the judge acting sua sponte, the judge has already got through that first threshold. In other words, no one's saying to the judge, you need to reconsider this whole thing. The judge is already doing that. The question is then for the judge, should that lead to a variation of the order? So that's why, as a matter of logic and as a matter of principle, we say there is a material distinction between the two. But, if I may, when I said both in relation to your initial question, my Lord, we also maintain the alternative position, which is that if your Lordships found that an unsatisfactory distinction, we would still say that the approach identified by the Court of Appeal should even arise for a judge acting sua sponte. In other words, there should be some compelling there should be some real reason for reopening the case and changing.
That's very close to exceptional circumstances, isn't it? I mean, one of the cases quoted in Riel, Mr. Justice Ricks, says strong reasons is perhaps an acceptable alternative to exceptional circumstances.
Yes.
And you're basically saying, well, exceptional circumstances are no good, but it's strong reasons. I mean, that's not consistent with Riel.
Well, we say it is, my Lord. The court. There were many cases in front of the Supreme Court which were identifying separate stages to the test. In other words, there's a sort of strong reasons test, and then the more, if you get through the strong reasons, then there's a more general discretionary, in a general sense, general discretionary exercise. No disquiet was expressed with those. Now, except I can't take the positive. I can't say they were endorsed by the Supreme Court, but we say that it is a proper conclusion to draw from the Supreme Court that they did not shut the door, so to speak, on the sort of submission which I am advancing and which the Court of Appeal did ultimately rely upon. If I can just make one point which is related, but it is, I just need to clarify something in the written case. There is something on, I don't know where people have the written case, but this is my written case. It's page 26 of the written case itself, which, if I look in the key documents, is page 101 through to 102. It is point 11.
What's the electronic page now?
So the electronic, yes, that will be.
I'm sorry, Mr. Key, I only use the electronic bundle, so I'm otherwise.
Yes, I unfortunately am sort of way behind the times, and I'm working with hard copy. So 140, my lord.
140.
140, yes.
Thank you.
So it's simply, as I don't want to make a mountain out of this. This is simply I'm saying that my reliance there on Stewart and Engel, I'm not sure is right, and so you can strike a line through that. I'm not relying on that submission, but the footnotes I do rely upon. In other words, when in the cold light of day, when I went back to read Stewart and Engel a couple of days ago, I'm not sure I'm right. I'm not sure I'm wrong. But it's so opaque in the judgment that I don't think I can rely upon, and I do not wish your lordships to spend inordinate amount of time on a point which may ultimately lead nowhere. But returning to the real point at issue, we say, firstly, there is a material distinction between judges acting sua sponte and applications in form or in substance made by dissatisfied litigants. And whether that is the case or not, as an alternative submission, we say that in any event, it is right to adopt the sort of structured discretionary approach described by the Court of Appeal, certainly to the cases where a litigant has made an application. And if your lordships disagree with me that there is a material distinction, then it would also apply to the case where a judge is acting sua sponte. In other words, a judge cannot just say, I have now alighted upon a piece of evidence and therefore I think that may make a difference and I want to hear the parties, etc., etc. That would be the wrong side of the line. But we don't need to go that far. As I say, my primary submission is that actually what we're addressing here in this case and what your lordships are focusing on is a case where an application has been made by a party, and it may be that your lordships do not need to go further than confining it to that specific circumstances, although I quite understand why your lordships may wish to do so. May wish to go further, but you have my submissions on that. We've spilt a lot of ink, or I have spilt a lot of ink, or a printer has spilt a lot of ink in my written case about issue 1. I don't want to repeat that at any length. May I summarise it by...
You were saying there's a structured discretion.
Yes.
One that involves a threshold requirement. Is that right?
Yes.
So you don't consider all the circumstances unless you've first shown compelling reason.
Yes, that's right. I mean, and to examine the consequences of that, I mean, there are obviously practical consequences, but let's look at the logical consequences. It is difficult to envisage, and we say one cannot envisage, a circumstance where one knocks it out at the initial phase, but would have permitted the application to succeed if it had just been a single unitary test. and I may be not expressing this well, but if I try
It
again.
depends what you mean by compelling reasons, doesn't it? And how you can find that. How do you define it?
Well, we know what the Court of Appeal has said, and the Court of Appeal has said a real prospect of success.
Oh, I see. That's how you define it.
Well, yes, and we've set it out. I mean, I'm only capturing what the Court of Appeal has said, and we say that the Court of Appeal is right in its summation, but we've tried to capture everywhere in a footnote where the Court of Appeal has said this, and this is in the it's paragraph 69, and that is, for those in the electronic bundle, that is...
Sorry, in the Court of Appeal judgment?
No, so this is in my written case. I apologise, my Lord. So what we're doing is we're pulling together in a single place everything the Court of Appeal said about it. And we're doing this in my written case, quoting the Court of Appeal.
All right, so can we have a page?
Yeah, so that's page 103, electronic bundle, and in my written case it's page 28.
You say that amounts to real prospect of success.
Well, that's what they say, my Lord, when we look at the footnote. Well, actually, I'm sorry, I misspoke. It's reasonably arguable. So footnotes.
I agree. Yeah. They seem to say something else and different.
Yeah.
I'm sorry, I don't seem to have what you want on my electronic one.
I am giving the wrong reference. It is page 142, my Lord. I'm very sorry. Yeah. So the key bundle reference.
I think we're looking at footnote 70.
Yes, footnote 70 is variations or explications of the more general description, which is found at the quotation at page 69, paragraph 69, the sufficiently compelling reason. And we do make the point...
But elsewhere they say there must be some principled basis for intervention. And I think what they're trying to get at is that there must be a basis for thinking that the finality principle is overcome by the circumstances, or could be on investigation.
I agree, my Lord. I agree both as to what that is what the Court of Appeal appears to be doing, and I agree that with the Court of Appeal's assumed statement and approach in that regard, and that we see. I believe
finality being either expressly or by implication part of the overriding objective.
Yes, and that's when they come to the disposition of what they call the stage, or what I call the stage one, what they call should the application be entertained as a matter of principle. So we see that.
It's a pity that we don't have the overriding objective to which reference was made in Riel in the bundle.
You're right, my Lord.
Is it in one of your footnotes, by any chance?
I have set out not a quotation, but I've set out the relevant things, and that is...
Because I think all the detail is under the general rubric of dealing with cases justly.
Yes. What I do somewhere or other, I say, it's page 36 of my written argument, that in the bundle, the electronic bundle is 150, and for those in the key bundle, it is 111. So, although I haven't quoted it, what I have done there is I have set, and you'll see at the end of paragraph 85.
I think the overriding objective has changed since Riel anyway, hasn't it?
Yes, I think you're right.
It's had the additional requirement of rule compliance added to it.
Correct. Yeah,
as an aspect of dealing with cases justly.
Yeah. So, I have, of course, the overriding objective in front of me. So, if there's any question, or
we can probably Google it.
Yes. Yeah, but I hope accurately my summation at the end of paragraph 85 fairly captures the individual elements which are reflected.
Oh yes, well you're using the modernised version.
Yeah.
I mean, clearly one wants to encourage judges to be robust and to be willing to say, well, there's nothing in this, I'm not going to entertain this application.
Yes. Yeah.
But the Court of Appeal seemed to have elevated it to another level and say that unless the judge goes through some structured process of reasoning and first gives reasons why it's reasonably arguable and then gives reasons why she's going to accede to it, that is some sort of error of principle.
I partially agree, my Lord, partially disagree. It is clear that the Court of Appeal has erected in terms what I call a first stage. Whether that is an initial hurdle or whatever metaphor one wants, that is what they have done. What is the practical consequence of it? And it maybe I misheard, but my Lord Legate, I heard suggesting that there would need to be, or it's envisaged, that there would be a judgment on stage one. And I don't think that is envisaged at all. Unless the case is to be dismissed at stage one, if the case proceeds to stage two, then the judge gives directions for the parties to file evidence, including the respondent to file evidence in response, and for the matter if necessary to come to an open court. So in other words,
that's what happened here. So what went wrong here then?
Well, there is no hint anywhere that the judge, we say, the judge turned her mind to stage one. All she did was what one would do as if there was a unity process.
Well, she gave directions for a hearing, which you say would ordinarily follow the stage one thought process.
Yes.
And her judgment, which we've all got in the bundles, was what you might call the stage two judgment.
Yes.
You, I suppose, could complain that she didn't explain what went through her mind before she gave directions for a hearing. But why should we suppose she didn't say to herself, "Good Lord, this is unusual. Should I go here at all?"
Well, for two reasons, my Lord. Reason number one, it is what one can draw from what happened as to whether, in fact, there is a stage one process happened. Exactly what we see would apply if there was a single unitary approach. In other words, if there was a single unitary approach and you didn't have a stage one, the judge would give directions, and you'd be in a hearing. So the fact that there were directions given, and the fact that a hearing was held tells us nothing about whether there was a stage one or stage two process. So it's neutral. Exactly the same would happen if it was a unitary process. Then, what we don't see is any hint or suggestion in the judgment. Not merely are there no reasons, there's no analysis of that question. And we say that is wrong, because at some stage or another the judge would have to reflect that question and the answer to that question. It doesn't need to be done in a separate judgment. In other words, you don't need to get through stage one, give a judgment, give directions, get all the parties into court. But you do need to reflect somewhere that the judge turned their mind to this, felt that there was a reasonably arguable case, and therefore in case management I gave directions and.
But if in her judgment the judge says this isn't merely arguable, it's actually right, I am going to reopen the order.
Yes.
She must be taken to be having thought it was arguable, which is all she has to do at stage one, according to your footnotes. It
is true that the manifestation of the judge's ruling will in part be reflected in directions, but
no, I don't mean the directions. I mean, if you read her judgment, she's saying changing this order is not just something which is arguable I should do. Having heard submissions about it, I'm going to do it.
Yes. Yes.
It must be, as it were, a subset or implicit in that at some earlier stage she thought it was arguable that she should do that.
Well, yes.
And that was why she was hearing argument on the subject.
Yes, and it does not tell us whether... My Lord, this is in some senses, I'm going to answer the question, but if I can just give a sort of practical position here. As I indicated in the written case and I indicated in my opening remarks, ultimately, whether it's a unitary process or a two-stage process, for the purposes of this appeal, we're going to have to get the facts. And as the judge did it, one had to get into the facts. So we can't draw a conclusion, we say, from the judgment where in circumstances as the Court of Appeal held, one or other of both things happened. Either she didn't ask the first stage question at all, or if she did ask it, she answered it incorrectly. Or, and we may be in a situation of stage 2. That's the alternative position put forward by the Court of Appeal. They say, they say that at paragraph 74. To the extent she did so, in other words, the judge erred in two respects. First, she didn't identify the first question, so that's you failed to go through the correct structure for the exercise of discretion. But in any event, even if you did, you got it wrong. I mean, it's just not reasonably arguable. And of course, sooner or later,
that's the nothing has changed point that you were arguing before. That reason.
Well, yes, that's certainly the way the Court of Appeal put it. In our written case, we put it slightly wider, but the number of it is right. That's right.
Yes, there were in fact three points in paragraph 74. One was the consideration of the first question. Yeah. Secondly, there was whether there was a change of circumstances, and thirdly, there was whether the reconsideration should be utilised in circumstances where the relevant event occurred after the order had been made.
Yes, so that, if one wanted to put it in a simplistic structural term, one would, it's encapsulated again in my paragraph 1 of my written case, where I said at heart that the issue is in circumstances where 1, 2, 3, 4, 5, would the Deputy Judge have made this, and one of those, to which my Lord Legate raises some debates with me, is about whether things have changed, but actually the others stand separately and of themselves would individually and collectively still lead to the same answer that the Court of Appeal reached in point 3 of its paragraph 74. In other words, in those circumstances, as a matter of principle, it was wrong either to permit reconsideration or, more fundamentally, if the reconsideration was to take place, to vary the order. So that's the. So if I draw the two strands together from the question from Lord Legate and the intervention or helpful assistance from Lord Briggs, part of it is right, my Lord Lord Legate, that it is partly the point 2, the significant change of circumstances, but it is not that only.
Well, do you support the last point? Do you say it can never be right in principle to take account of something that's happened after you gave judgment, but before the order's drawn up?
No, we don't say that at all. But that's...
Isn't that, well, that's what they are saying here, isn't it?
Well, they say in breach of earlier orders of the court. So we separate out two questions. Number one is, could an event, so let's say some building falls down, which is the subject of litigation after the oral order is made. Of course, Ladder Marshall or similar principles, if it's not exactly Ladder Marshall, but introduction of new evidence, of course that could be permitted. But what one couldn't do is have a debate about the integrity of the house, be under an order to demolish it, breach that, and then after the oral order is made, demolish the house, and then say, oh, look, the house got demolished. That would not be permissible. So we don't want to be, we're not casting it too broadly, my Lord, we hope, and I hope that answers the question. So I'm conscious...
And what was the order of the court that producing the guarantee was in breach of?
So it's the first Berlin order as modified by the subsequent orders. So for those who are in the key file, it is page 159. For those who are in the electronic file, it is page 311. and that's it. So it's the first Berlin order, and it is paragraph 2. That's page 160. 160 key, 312.
I can see that not providing a guarantee is a breach of the order, but I'm slightly struggling with the notion that providing one is a breach of the order.
Oh, sorry, I may have completely misunderstood. So provide. Yes, on my understanding, on my reading of the Court of Appeal, one needs to include an ellipsis, which is not there, which is that the gist of what the Court of Appeal is saying is that the late production is in breach of the earlier, the failure to produce was in breach, and that by producing it late, you necessarily were in breach of early orders. It's not the fact of production which is the breach, it is the absence of production prior to production which is the breach. And I realise that, as written, it may not exactly express that.
Timely production, yes.
Yeah.
Thank you. Now,
so
I want to move on to other matters. I appreciate that you're, while the court's concern, obviously, with the structure of the law, is focused on issue 1, you want to deal with the exercise of discretion and justifying the Court of Appeal's view that they were entitled to exercise the discretion anew.
That's entirely correct, my lord, and on that basis, I think it's important that the documents, the factual position, is shown to your lordships. So, with what I'm about to show you, there are 4 central points I'm focusing on. I won't make them on every document or everything, but here are the points. Number 1 is the delay, and by delay, I mean the delay in producing the guarantee as ordered under the first Berlin order that we've just been looking at. Related to that, I call also part 1, or point 1, the absence of any legitimate excuse for that delay. So it's delay, what's the reason for the delay? That's point 1. Point 2 is breaches of orders, so FAAN's breaches of orders made by the court. Point 3, the statements made by FAAN to the court regarding the consequences if the guarantee was not provided by the end of the 5th of December 2019. And the 4th point is the position adopted by FAAN in the lead-up, the days leading up to the hearing of 6th of and actually at that hearing. I'm not saying those are the only things I'm going to be looking at, but if one has those in mind, you may be able, as we go along, to read the documents and place particular points in one or other of those pigeonholes. So, I start with, I'm going to do this reasonably quickly with each of the documents, so please, if I'm going too quickly or someone doesn't have the document, please stop me. The first document I'd like to look at is the first judgment of the court, of the deputy judge, and that is the judgment of the 13th of August. This is the judgment where the judge had to rule upon whether there should be enforcement or whether it should be adjourned pending the provision of some form of security. The judgment is in Key Bundles 13, Electronic Bundle, page 300. Did I say 30? Key Bundles 193 and Electronic 300. And there's only a few points I want to take from this, so I'll do this reasonably quickly. And in some senses, it is to make good propositions that we have set out in the written case. The first is found at paragraphs 43 to 44. And this is, they are long paragraphs. And the central point is this is where the Deputy Judge reaches her conclusion about the weakness of the set-aside application which is taking place in Nigeria. And she concludes, paragraph 44, that she, quote, would not consider the set-aside application to have a real prospect of success on appeal, end quote. But as I stated in the written case, I think in a footnote, she felt that she needed to take account of the fact that there had been an earlier first instance judgment in Nigeria which did in fact set aside the award, even if she disagreed with that, and that needed to be weighed into the balance. So her conclusion, and there was never any dissent from that in terms of an appeal or otherwise, was that the set-aside application in Nigeria did not have a real prospect of success. So that's point one. Point two, paragraph 49. FAAN, the appellant in this case, has its own funds. And we see this about 7 lines down in paragraph 49. Contrary to FAAN's evidence, the revenues in question clearly are FAAN's and not those of the federal government of Nigeria. And dropping down towards the bottom of that paragraph, the obvious inference I draw from this lack of documentary evidence is that bare assertions to the effect that the revenues in question do not belong to FAAN cannot be relied upon. So the judge reaches a conclusion that FAAN does have its own revenues. Paragraph 51, she reaches a conclusion that they are considerable. I'm not seeing the word considerable, although it does appear. It is certainly clear that
it's the last word in paragraph.
Oh yes, I'm sorry. Yes, yes. So that's why we have FAAN has its own funds, and the revenues are considerable. Paragraph 54. That there is prejudice to my client, AIC, inherent in the continuing delay in enforcement. That's it's the top of the page on the right-hand side. The whole sentence reads, taking it up.
This is because the learned deputy judge came to the view that the award was
manifestly valid.
Manifestly valid
Yes.
criterion. Yes.
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 So there is inherent prejudice just by not enforcing the award and by AIC being kept out of its money. And paragraph 60, the final or penultimate paragraph, this is where the deputy judge makes her ruling on the provision of security. So weighing everything up, she decides to adjourn the application for enforcement, but that is upon the provision of security. And she says that some 7 lines into paragraph 60, I am satisfied there should be security as a condition of the grant of the adjournment and that it would be reasonable for this to be in a sum of ... So, it is clear, this is to make good the proposition which is established in the Court of Appeal that the security, the need for security was clear from the 13th of August, that there could be no reasonable doubt as to what form it would be in. I say that because my client had previously asked and this is in, we don't need to turn it up, it's in the electronic bundle, page 625, as part of the application for security, we'd ask for either deposit of cash or a first-class bank guarantee. As the Court of Appeal said, that is what you can reasonably expect to be required when security is ordered. And the very day after this judgment, namely on the 14th of August, the process started between counsel for the two sides of agreeing the wording of security by way of a guarantee. And that we see in two places. Again, we don't need to turn it up. It's in a skeleton argument, which was for the 13th of August. It's reflected on page 436 of the general bundle, or electronic bundle, and in paragraph 12 of a witness statement, which is on page 755. 755. So, we say, as did the Court of Appeal, it was right that FAAN should start at or very shortly after the date of 13 August to get the funds available released either for payment into court or a bank guarantee to be issued, and there can be no doubt about that. The fact that the order, the precise terms of the order, were not made orally or otherwise until the 17th of September is neither here nor there. The process needed to start on the 13th, 14th or 15th of August, but it did not. So that's the first document. The second document we have just been looking at, which is the what we call the First Berlin Order. That is in key documents at 159, electronic at 311. And that is the order which arose to settle the terms of the security that was to be provided. And as we say, that 5 or 6 week gap between the 13th of August and the 17th of September can't be regarded as dead time, so to speak, for FAAN. It was where they needed to be doing something. We know at the 17th of September hearing that FAAN was asking, this is referred to by the Court of Appeal, FAAN was asking for 3 months. 3 months to provide their security. And we don't need to turn up yet because we'll look at it later, but that's reflected amongst other places in a letter from FAAN itself, dated the 2nd of October, General Bundle, pages 666 to 667, paragraphs 6 to 7. AIC was asking, my client was asking for 4 weeks from the 17th of September. The FAAN side was asking for 3 months. The judge ordered 6 weeks. So,
how was that? Was there a hearing, or was it just dealt with on paper?
It appears, firstly, neither counsel here, my lord, were representing their respective clients at that stage. But if one looks at the order, one sees upon hearing leading counsel for the claimant and counsel for the defendant. So, and that is the last recital above the "it is ordered." So it seems
there must have been a hearing, yes.
Yeah, and that's also consistent with the letters that one has. What one gets is letters from FAAN, including the letter that I was just describing, the letter of 2 October, where they report back on what happened at that hearing.
Well, I think the order speaks for itself.
Yes, yeah.
But the order is actually relating to the substantive hearing, isn't it?
Yes, that's right. It's having ordered. So I won't drag your lordship.
You said there was a hearing on the 17th.
Yes, exactly. I won't drag your lordship back into it. But on the 13th of August, the very last paragraph, as can be expected, the judge says, words to the effect of, "I hope counsel will be able to draw up the order. If there's any difficulties, then we'll deal with that." And so I don't think either counsel can assist you as to what precisely happened between the 13th of August and the 17th of September. But we do know there was a debate. There was a debate as to how long there should be for the terms of the guarantee, and that wasn't exactly splitting the difference. But for material purposes, FAAN's submission that there should be 3 months was rejected by the court.
Was there any debate about the terms of the guarantee?
I do not know. There's no material in. I pretty much read every line of every page. I am not aware of any material which tells you either way, my lord, whether there was or was not a debate. So I can't assist there, and I think it would be wrong for me to start ad hoc speculating. Yeah. So. What then needed to happen in practical terms for FAAN to comply with that order? Well, not difficult, not rocket science. One of two things needed to happen. Either FAAN needed to arrange it itself by reference to its own funds. That's option one. Or option two, FAAN needed to arrange the security with the assistance of the Nigerian state, with a central bank or a minister or otherwise. Those are the two options. Now, it is clear, both from what we have already seen about the fact that FAAN has its own funds and the funds are considerable, that it could pursue option one. If you want to know more detail about the viability of option one, I would suggest for your note one looks at AIC's skeleton, my client's skeleton for the 6th of December hearing. That's in the general bundle at page 455, and it's paragraphs 29 to 38. So in other words, it set out very clearly why it was an entirely feasible option for FAAN to proceed to arrange the security on its own steam, under its own funds. That's set out there. It's also set out in paragraph 30, subparagraph 3 of my client's skeleton before the Court of Appeal, which is at general bundle page 412. So that's option one. It didn't pursue option one, and there's no suggestion that it even contemplated it. Instead, it pursued option two, which was to gain the assistance of the Nigerian state. Now, we're going to look at what happened, not exactly blow by blow, but not a million miles from it, but I want to cut to the chase. Let's see what could happen when the will was there to provide this guarantee. And we can see it if we open up general bundle, electronic bundle at page 720. In fact, I'm going to tell you what happens, and then we'll look at the documents. In practical terms, what needed to happen at worst was FAAN needed to ask the Minister of Finance to arrange it. The Minister of Finance writes to the central bank, and the central bank arranges the guarantee. That's it. So FAAN does indeed write to the Minister of Finance, and then the Minister of Finance at page 720 decides to write to the Governor of the Central Bank of Nigeria. And this is one of the slightly wobbly documents which I will try to assist your lordships with. This is the first time that there is any document going to or from the Central Bank of Nigeria, the 2nd of August.
2nd of December.
Sorry, yes, critical. I will quickly, if I may read, just because it's quite difficult.
It's very simple, really, actually. The bottom of the page, he hereby requests that you take immediate steps to ensure the issuance of the guarantee in 24 million US dollars.
Absolutely, my lord.
I mean, that's the point.
Yeah, that's 2nd of August. Sorry, I'm doing it again, 2nd of December. The 5th of December is the next document, document 722. It's not clear what has gone on between but there's another thing from the Minister of Finance, or Ministry of Finance, and indeed it is from the Minister of Finance, and authorises the central bank to block the relevant sum. Now, we're getting slightly into the weeds with my next point, but I'll make it. There is a reference in the third line to funds held with JP Morgan Chase. In fact, as you will note, that is not who ultimately provided the guarantee. It is Standard Chartered Bank.
Chartered.
Yeah, so in fact things, all happened in a blinding flash on the 5th of, on the sort of evening of the 5th of December with Standard Chartered Bank. It's never been explained what the problem was with JP Morgan and when things kicked off with Standard Chartered Bank, but this is what we have. So that is the 5th of December. And then the guarantee is issued, as we know, on the 6th of December. Once the will was there to provide the guarantee, it could be provided, it seems, in some 4 or so days. And given that the letter of the 5th of December 2019 refers, that's the document we've just been looking at, page 722, it references the wrong bank, perhaps it's even considerably less than 4 days. And in any event, as the Court of Appeal rightly noted at paragraph 21 of its judgment, following a request by FAAN, the provision of the guarantee by or through the Ministry of Finance should have been a formality, given that FAAN is an agency of the Nigerian state and FAAN's part of the same entity as the Nigerian state ministries.
Is that any evidence?
Well, yes, I tried to summarise in the written case. I don't have the reference, but amongst other things, I do recall that one has is a statement. The relationship is actually described in the 13th of August 2019 judgment of the Deputy Judge, but I have put it somewhere in I think it's in the background.
Well, I entirely understand your point that they showed they could get their act together very quickly, but are you saying, I didn't really understand your basis for saying that they went through a needless process of asking the Ministry of Finance, if that's what you're saying?
No. I'm not saying. Well, I'm not saying that at all. Other than I am saying, they actually did not need to. There was another alternative. In other words, if they thought there was some problem with the Ministry of Finance, they had another alternative, which was option 1, which they didn't pursue at all, not explained. But as it turned out, option 2 was perfectly viable. As I say, where there was once the will crystallised, it became very straightforward in practical terms for that guarantee to be issued. So that is.
But there had been prior steps to that letter of 2nd of December.
Well, yes, and we're about to look at those. As I mentioned, my Lord, that was the cut to the chase.
Right.
Now let's look at actually what happened. So we need to go back to the 2nd of October, and that is a letter in the electronic bundle at page 666. So that is the first document that we see following the judgment of the 13th of August. It's not merely the first document after the 17th of September order, it's the first document after the 13th of August. And that, in some senses, speaks for itself. It is a document which is to the
Attorney General.
Yes, and it seems to be the same office holder, Attorney General and Minister of Justice. Yes. And it seems to be the same person holds those two offices. And essentially, what this does, I won't agonise over it, but it records what's happened at the hearings. And it then says it reflects that there is an order to provide security, that's paragraph 8, and then there is an application for leave to appeal which is contemplated by FAAN. And this is and paragraph 18, last paragraph, this is for your information and further directives. Now,
paragraph 17 makes it clear that there is the order for the guarantee and also an order to pay costs.
Yes, yeah. So that's the first that we see. There is absolutely no explanation ever provided of the gap between this date and the earlier 13th of August judgment, or indeed the 17th of September order. And just to give some concrete numbers or time periods, time intervals for those, the judgment on the 13th of August is more than 7 weeks earlier. This is 50 days, 50 days after that judgment. And the 17th of September order occurred 2 weeks earlier. This is 15 days later. Never any explanation as to what was happening, why, if nothing was happening, why nothing was happening. So that's
whether you need to be doing something then depends on how quickly you expect it to be done, doesn't it? I mean, if it's only going to take 5 days, you can wait till you get the order.
Yes, well, that may be correct in some situations, but in fact one knows, my Lord, that what is described later, when it gets to what we say are sort of applications which are calculated applications designed to achieve a particular purpose to get time. What one sees is the evidence support is that we're running into, is that there are difficulties, and they're never explained, and it's like, what are these difficulties? Mm-hmm. Further, it's never explained why the Minister of Finance isn't being written to at this stage. This is, the Minister of Finance is written to at a point in time, but some 2 weeks later. And if in what seems to be the world that we know from having cut to the chase, what needs to unlock the process is the Minister of Finance, FAAN can write to the Minister of Finance because it does so. In other words, it does not need to go through all these other ministries to get their buy-in approval, and there's no evidence that it needed to. So this is an interesting letter, but actually it's not part of the critical path. Right. What we then get is the letter at 670, which is the next document in the electronic file. So this is, as one sees, to the Minister of Finance. And what one, again, cutting to the chase, paragraph 11, FAAN asks the Minister of Finance to provide the guarantee. 15th of October. Now, again, to give some chronological or temporal sense as to where we are in relation to the earlier periods of time, this is now 63 days after the 13th of August judgment. So it's 9 weeks, thereabouts, later. It seems that there was then, turning on to the next document, and we can do that, we can pick up...
Can I just check?
Please, my Lord.
Just before you move on, does this inform the Ministry of Finance of the deadline for the provision of this guarantee?
Yes, it is paragraph 6. Yes.
Oh, thank you. Yeah. Well, yes.
So the next document, and as I say, we can pick up pace a little bit, but again, we're subject to any questions or concerns which are arising. Document at page 673. And again, it's back to the Ministry of Aviation, and we see just so there's no confusion, we see a reference in a letter in the first substantive line, which has never been disclosed. We refer to the Honourable Minister to the letter dated 23rd of August 2019. We have never seen that, have no idea what it says, but It's supposedly attached, but we haven't seen the attachment. So, in any event, I don't think it's necessarily going to advance matters much if either it revealed the need to get security, and there was no action taken on it, or it didn't reveal the need for security, in which case that problem is FAAN's problem. Either way, we say it's FAAN's problem. But in any event, what happens is there is this letter of the 21st of August. Again, like many of these documents, it in broad terms speaks for itself. It records a number of events which have been taking place over the previous days, including meetings with two law firms in parallel, a meeting with the Solicitor General, meeting with the Minister of Justice, and the like. This is in large part the basis upon which the Court of Appeal makes the finding comment that the focus seemed to be on the appeal as opposed to provision of the guarantee.
Yes,
and we see that
it was the firm Curtis trying to replace Joseph Aronson.
That's right, and the reference in particular is at paragraph 13, top of page 675,
yes,
where the comment is made that the existing law firm who's to be replaced had no immediate proactive solution to the present and urgent problem at hand. And actually, when one reads the letter in context, the urgent problem is not how do we get the money, it's that we've been ordered to get the money. And what they want to do is to find some way to get rid of that obligation.
That's paragraph 10.
Yes, my Lord. What I cannot assist your lordships with is page 676. This is one of the illegible documents. I do not know that we've ever had a copy, and if it mattered, it would have been produced a long time ago, so that's it. We then get a series of documents going back and forth. Essentially, it is FAAN to one or other of various ministries, or vice versa, coming back from the ministries. So we get 677, we get the Ministry of Aviation writing to FAAN saying, we've approved your guarantee. Not clear that they actually ever needed that. So evidence to that effect, but that's what in practice happened. The Ministry of Aviation gave their approval. We are now at the 25th of October, and just to remind ourselves, the critical date is the 29th of October. That's when they've got to provide this guarantee. On the 29th of October, the very last day, we get to the letter at 678. And that is FAAN to Minister of Justice, Attorney General, same person. And in parallel with that, FAAN issued its application for a stay of the order requiring security. So to loop back and just, we don't need to look at the documents, but just to make to fill in the gaps, backfill, as is sometimes said. Number one, FAAN had already issued an application for permission to appeal in time against the order, or against, in fact, the judgment requiring it to provide security. So there was an extant application for permission to appeal, and by virtue of the order of 17 September, the date for provision of the security was the 29th of October. So what FAAN did on that day, being the last day, is it makes an application to the Court of Appeal for a stay of the requirement to provide the guarantee, and that's at page 680. And
which number, sorry?
680, my lord. It's the electronic bundle. Yeah.
Yes, I have it.
The Appeal criticised that, but
Could it be
why does
criticised?
it matter? I mean, if it had been made 2 weeks before, we would have to grant the stay pending permission, wouldn't they?
It may not, but I think what the Court of Appeal is drawing, and it may go nowhere, is just it's a point I made in my written case. And again, it may go nowhere, but there is a disturbing habit of last-minute applications. In other words, FAAN seems to scramble around at the very last minute, or in some cases after the last minute, or just doesn't do anything at all. And as an example of at this stage, just not doing anything at all, it had already been required under the 17th of September order to pay 45,000 odd of costs. Those were unpaid at this date. So it makes its application, and it is. We see the application, the grounds, at 684 to 685. Now, and without being too harsh, if we look at paragraph 3, this is bordering on incoherent. And I particularly look at the third sentence onwards. Enforcement by the claimants in this matter would stifle the appeal process as the significant amount of security ordered affords considerable impediments in this jurisdiction to the defendant there to collate the funds. Such impediments run contrary to what was said in Gold Rail Travel Limited. The defendants have been axiomatic in their response regarding their funds within the UK. They cannot immediately provide the 24 million odd, and thus the enforcement of this order would breach the defendant's Article 6 rights. So I won't comment further, but that is what they say. Now, we know that if we just follow this little thread through, that Lord Justice, this particular application comes before Lord Justice Coulson. And Lord Justice Coulson extends time. It's in that particular ruling is at the General Bundle, page 313. And it's in, if anyone's using the core, it is in 161. And so time.
The general page number?
So the electronic bundle is 313.
Thank you.
Yeah.
Got it.
And he ties it, or Justice Coulson ties it to the ruling on the application for permission to appeal. Now, as Lord Justice Coulson himself identified in the Court of Appeal judgment under appeal in this case, he at paragraphs 24 and 84 noted that he was left with what he called, quote, no realistic alternative, close quote, and no real option, close quote, other than to grant the extension of time. But he also goes on to say that in the Court of Appeal judgment that, of course, as we know now, the appeal application for permission to appeal was dismissed, and it was an application without a reasonable prospect of success, it's another way, without merit. So, in other words, to draw the strings together, the previous date had been the 29th of October. Because of an application which was without merit for permission to appeal.
You say without merit, it was dismissed. It wasn't said to be totally without merit, was it?
Well, yes. I think, in terms of his ruling, which is at 315, I think that's right. It's just
it's not a TWM order.
No. But I think Lord Justice Coulson does have some comments about it in the Court of Appeal judgment under appeal, and I think though it is fair to say that gives his view of that. So that is the so they get the benefit of an application made off the back of an application for permission to appeal, which failed.
So this case is all in the Court of Appeal judgment, isn't it? Why are we going through all this detail?
Yes, I see that, and I can jump for it. If I may just take 20 seconds, and I'll just make sure there's nothing critical that I am missing. In some, I wanted to show it to your lordships because, in some senses, the matters come to life when one starts to see these sort of many and varied different comments being made. I think what I can do is I can then take it up.
What is striking is that the public authorities in Nigeria didn't seem, FAAN and the public authorities didn't seem to do anything at all until well into October. And once you were in October, they don't seem to have treated the matter with very much urgency.
No, that is entirely accurate, my lord, and
which is why I called into question the judge's characterisation of there being good reasons in paragraph 29 of her judgment.
Yes, we entirely agree, my lord, and we've seen, of course, what happens when the will is there to provide, how quickly it can take place. So, I won't, unless your lordships wish me to do so, I won't take your lordships to the various statements which were made in relation to the next stage, which is the application for a further extension of time. But if I can broadly summarise it without reference yet, and I hope to avoid it, without reference to the underlying documents, what happens is Lord Justice Coulson rejects permission to appeal, dismisses that. The new time then for provision of the guarantee becomes 14th of November. So that is the date, and that was the actual date, which was in place when the judge made her ruling on the 6th of December. It never changed after that until the judge gave a variation or by her order of the 13th of December, treated the guarantee as being in time. But in fact, the effective date by which the guarantee was provided was the 14th of November. An application was made for an extension, for a further extension of time, and that is the application where, as I've indicated in the written case and the Court of Appeals referred to, and your lordships are undoubtedly well aware of, various statements were made about the consequences if the requested extension of time still did not lead to the guarantee. So the application is made on the 14th of November. That's, we won't look at it unless you wish to, but that's at page 692. There is a witness statement in support of that application. That's at page 695. That's one of the places where it's... So they're asking for a 3-week extension, and that 3-week extension will take them to the 5th of December. There is a statement in the witness statement in support at page 695, paragraph 6, as to the consequence if that extended period of time still does not lead to the guarantee. In other words, if you give us this an extension of time, court, we will provide the guarantee, and if we don't, then respondent is at liberty to enforce the award, not at liberty to apply, but at liberty to enforce the award. That is the quid pro quo for our request. The paragraph 4 of the grounds at page 697 has a reference to some vague idea as to the time being for so that the security bank guarantee can be formalised. That was the ground. paragraph 4, page 697. The reason being put forward is not, oh, we're having extreme difficulties with our bank and the central bank or whatever else might be regarded by them as a legitimate excuse. It was tied to somehow or another the formalities. And similar wording appears at page 700, which is the draft order. This is the draft order in relation to the extension of time that FAAN is asking for. And they need to, as they call it, finalise the security under paragraph 1. But that, in our respectful submission, was a somewhat inaccurate, to put it mildly, statement of what was going on. This wasn't about finalising the security. It wasn't about formalising the security or bank guarantee. It was that no one in Nigeria was doing what they needed to do. And I mean, that's not necessarily a criticism of what's happening in Nigeria, but just that you can't have your cake and eat it too. You can't both do nothing, or those who own you and in control of you do nothing, and get the benefit of some judicial discretion which says, oh, that's all okay. It's not. So that's the application. And similarly, we get a letter written by FAAN to the court, which is at page 703, which again has the what I call the quid pro quo. In other words, here is our application for an extension of time, court. The quid pro quo, we want 3 weeks. If you give us the 3 weeks, the quid pro quo is that if we still don't manage to get the guarantee, AIC can enforce. And that's the last paragraph. FAAN has therefore respectfully requested the court to exercise its discretion as matter to grant a short stay of 3 weeks, whereupon the claimants will be liable to enforce the award should no bank guarantee be in place. Fine.
But that isn't actually what the court had ordered, is it? Now, why was the order not for liberty to enforce the award if the guarantee is not in place? Seems a bit odd that it wasn't.
I agree, my lord. I can't answer that. It would be entire speculation. I wasn't involved and don't have even...
But it's not apparent anyway, you say, from the reasons.
No. There is no trace of an explanation one way or the other. It's just neutral in terms of material. So, if one of the points your lordship was alighting on was the difference between the wording in the order and the wording here, we would say that is it's right to note that difference. It's not suggested that claimants will be, AIC, my client, will be at liberty to apply to enforce the award if that was any different. It is actually, they'll be enforcing it. There will be no resistance. It will be, enforcement will follow if we have not provided the guarantee by 5 December. So it's what I colloquially call, maybe inaccurately, FAAN telling the court, telling my client, here is our last chance saloon. And we accept that it's our last chance saloon. If you give us the 3 weeks, we'll either comply, and if we don't comply, then the award will be enforced. That's the quid pro quo. That's the gist of those various 3, in fact, statements made in the application, the witness statement, and that letter to the court. So if we pause here and try to draw everything together, and then we can move quickly to the last stages, the 6th of December and the 13th of December judgment. We've had a guarantee which was originally ordered, well, a security ordered to be provided, and that was ordered, or it was clear from the judgment, delivered on the 13th of August. And the quantum of that guarantee was identified in the judgment, namely just over 24 million. The precise terms of the guarantee, or the security, was settled by order of the 17th of September, with the guarantee to be provided by the 29th of October. And that's a 6-week period from 17th September. FAAN didn't comply with that obligation or order. FAAN applied for a stay on the very last day for compliance, namely the 29th of October, and it got, and that was off the back of an application for permission to appeal, which was rejected. By virtue of that application, it got a further period of time, which operated in actual fact until the 14th of October, giving FAAN in total over 8 weeks from the date of the
November.
From 17th of September to 14th of November. So that's 8 weeks to provide the guarantee. Even if one treats the starting point, the formalisation of the provision of security by virtue of the order of 17th of September, which of course we say is not the right date, it's an early date. There were periods in August, September and October where nothing concrete as regards the making of requests by FAAN to the relevant governmental bodies, whoever they may be, and I'll come back to that, for the guarantee to be provided appears to have been done. As I say, the critical ministry to unlock everything seems to have been the Ministry of Finance, and the request was made, but nothing seems to have been done. So when the requests are made, nothing happens. The Ministry of Aviation had approved the guarantee by the 25th of October. Ministry of Finance had been directly asked. Nothing had happened. As regards costs, there had been a breach of the costs order, and that was ultimately paid on the 15th of October 2019, which is Lord Justice Coulson observed in the Court of Appeal judgment. Payment of costs appears to have been linked to the indulgence that FAAN was seeking, having just issued an application for, no, sorry, I'm wrong with that, that it was, I think, all I can say is that it was a substantially late payment of costs. There is a later cost order which they do pay in connection with applications coming up. But the order of 17th September required those costs to be paid by the 15th of October. I think I may have said they were paid. They were not paid at this stage. They had not been paid at all. So there was still 44,000 odd.
Did you say they were paid on the 11th of December 2019?
Yes, that's absolutely right, my Lord.
Just on the eve of the hearing?
That's right, my Lord. Yes, you're ahead of me, and that's unsurprising. And as we've just been looking at, FAAN accepted that the guarantee needed to be in place by the 5th of December at the latest, and that if it was not, the award was to be enforced. So 5th of December was, however one phrases it, the final date. We then get application to enforce the award by my client. That takes place on the 21st of November. And we can take it forward, I think now, to the around the critical dates to December onwards. We've already seen some of the documents, so we don't need to dwell. So we get the document at which we have already seen at 7:20, which starts things off, the Ministry of Finance running to the central bank. What we haven't yet seen is at least in the course of this oral hearing, is the statement of Dr. Omozigian, which is made in connection with the applications the application which FAAN is pursuing at this stage, namely the application to extend time to the 5th of December. And that document is at 7:23. It's a very short document, and that is a document which is placed before the Deputy Judge on the 6th of December, and she records that that's been placed in front of her. I'm not sure that she records it, I don't recall either way. I don't recall if she records it on the 6th of December or the 13th of December, but it is clear from one or other of her judgments that she had the document on the 6th of December hearing. And this is the source of the unfailing comment. It's paragraph 3, last sentence. In fact, my note tells me that the Deputy Judge records it in paragraph 8 of her 13 December judgment that she received it on the 5th of December. Then we see a skeleton argument from the FAAN side. We have to jump back, I fear, to page 480. And this again gives a sense as to what FAAN's position was. So, skeleton argument, it indicates that the guarantee is not in place, but is on the verge of being issued. So the paragraphs, whether now or later to read, it's only a short skeleton, but the critical paragraphs are 1, 2 sub 1, 3, and 12. So this is a skeleton on the 5th of December. It's for a hearing on the 6th of December, which has already been indicated in this hearing, was specially arranged on the basis that the guarantee would already have been provided or not at that stage, and the consequences would follow. Either it would be in place, in which case then that might count towards an extension of time, or it wouldn't be in place, in which case enforcement would follow. So there is reference to obviously this is in support in part of an application to extend time. The only application at that date was an application to the 5th of December, but it is unclear whether in fact counsel for FAAN at that stage was contemplating a yet further application. It's just unclear. I mean, it is, as your lordships realise, our submission is that such an application could have been made if FAAN so chose, and the only application, in fact, in existence on paper was the 5th of December, and no application was advanced at all on the 6th.
When was the hearing fixed for the 6th?
That I do not know, but I do know I know that it was fixed by Mr. Justice Fraser. So I get this from page 437 of the general bundle, of the electronic bundle, which is my client's skeleton for the 13th of December. It's not my skeleton, but it is skeleton for my client. And what I see there is that paragraph 8.3 doesn't give a date, but that Mr. Justice Fraser listed an application to be heard. So when it was listed, I do not know, my lord, but that's as far as I can take it.
Well, one can assume that they were hoping to turn up on the 6th of December and say, we've got the guarantee, so please extend it to today. Yes. They weren't planning to turn up and say, sorry, it didn't arrive yesterday, so our application was fail, even though it's now in our hands. I mean,
and my lord, on the basis of the three sources that we've seen, witness statement, grounds of application, and letter to the court, they've been telling the court and my client, and if we don't have the guarantee by that date, the award's going to be enforced. So one way or the other, remember that by this stage, my client had also put forward an application to enforce the award, or renewed its application if one wants, so that matters were coming to a final head on the 6th of December. And one way or the other, that was going to be the end of it. In terms of either extension of time to provide the guarantee, and a retrospective extension of time in some senses, or if there was no guarantee around, then there was going to be enforcement of the award. That's the position. That's what happened. And we say that should have been where matters rested on the 6th of December.
We've no knowledge from the documentation as to why FAAN moved from JP Morgan and instructed Standard Chartered to provide the guarantee on the 5th of December.
No, there is nothing, no hint of that in the documents, nor has there been any explanation.
We simply know that Standard Chartered were first approached on the 5th of December.
That seems to be the case, my lord, yes. I mean, some points are made about that it doesn't take us any further, by my client or through my client's previous counsel in relation to the hearing of the 13th of December in the skeleton argument, but it doesn't. But there's no explanation. It's just making arguments off the back of what I think my Lord Hodge you fairly summarised there. So that's the hearing of the 6th. That's the ground for the 6th of December hearing. The 6th of December hearing, we have the transcript. I don't need to take you to that. I have quoted, perhaps inappropriately, but I have quoted in footnotes to the skeleton, to the written case, some points we need to make that, but you know the critical points. No opposition to the enforcement application, no opposition to the order being made, invitation to do something but not taken up by anybody, and that is where matters rested. Now, what we then get, of course, and as your lordships already know, and as my learned friend has already taken you to, the guarantee arrives, and the application is made to reconsider, and matters are then dealt with by way of service of witness statement evidence, skeleton arguments, oral submissions, and a judgment. Now, what I think I should, in fairness, do, it may be very brief, but I better critique, if I can, very quickly, the judgment of 13 December. That is the...
You've got 3 minutes.
3, okay. So we're very...
The point I'm hoping you'll deal with, which is the one that troubles me most, is that is the windfall point. Because
yes.
This is what the judge regarded as critical. If it had simply been a case of you've had your chance and you didn't make it in time, I can well see there's no possible reason to say, well, now you've come up with a guarantee, I'm going to reconsider. But then the situation has changed because now you've got the benefit of something you were never intended to have. That was what made the judge change her mind. And what I want to know is why she was wrong to consider that was or not entitled to consider that was a critical factor.
So, my Lord, as a general point, we don't accept, obviously everyone can read the judgment for themselves, but we don't accept that was the critical factor. It was a factor which the judge took into account. We, and indeed the Court of Appeal agreed, say it was a wrong factor to be taken into account. But if we're wrong about that, and it was a factor that the judge was right to take that into account, it wasn't, I don't think it was the critical or determinative factor, and we say it wouldn't alter anything. But in any event, let me deal with the point head on. Firstly, we agree with the observations, conclusions of the Court of Appeal in paragraph 97 as to this. In other words, what seems to have happened is that we are criticised for having called on the guarantee. Some fairly obvious points. The order for enforcement had been made. That's clear, 6th of December. We'd been provided with a guarantee which entitled us, my client, to call on the guarantee in the event that an order for enforcement had been made. FAAN could have achieved whatever it was trying to achieve without providing us with the actual guarantee, but it did. My client was doing what it was entitled to do. It was entitled to call upon a guarantee which said, in the event of an order for enforcement, paraphrasing here, you can call on the guarantee, your first demand guarantee. And the criticism which the deputy judge levels ignores the reality of the legal position. So what?
It's not so much the criticism, but the fact it's a changed circumstance.
Yeah. But the judge is just referring to that to say is what it illustrates is that they'll now be having to pay up under a guarantee which was never intended to fulfil this function.
Yes, But the way that, and of course that is a different situation. But we say that's not a materially different situation, or not one which is going to alter the exercise of a discretion, whether structured or unstructured. And what in our respectful submission, the deputy judge has done is ignored what we say is the reality of the legal position. Because what the deputy judge does is she posits a scenario, and what I'm doing here is looking at paragraphs, this is 19 to 20. She posits a scenario whereby the enforcement order is not revoked or set aside. So that's her starting point. She says, she doesn't say this in terms, but that's the gist of what she says. Let's examine the position if the enforcement order is not revoked or set aside. Well, in that case, there would be a valid order for enforcement, which, subject to any appeal, would stand. It would make my client a judgment creditor in the sum of approximately $150 million, and FAAN would be obliged to pay that judgment debtor. And what I ask rhetorically would be unjust about AIC, my client, receiving partial discharge of the judgment debt.
I fully see the point. I mean, you're critiquing the demand under the comment that the demand was inappropriate, but I think the gravamen of the point that my colleagues are putting to you is that there was an unforeseen windfall in that that your clients received both an order for enforcement or an entitlement to enforce and a guarantee which had been conceived earlier as avoiding that order to enforce. I think that's the key point. I think Lord Leggett is nodding.
Yes.
That's it.
I'm sorry.
Don't waste time on the question of whether the demand was inappropriate. I for one, am perfectly happy to accept it wasn't. The question is, was the windfall so described, was that a circumstance which was sufficient to justify what the deputy judge did?
So three very brief answers. I'm very conscious of the time. Number one, we do not accept, in fact, we vehemently disagree with the suggestion that the starting hypothesis that this is a windfall. It's not a windfall. It's the discharge of a legitimate debt. That's not a windfall. The debt exists. Number two, to actually see whether, in other words, to consider the exercise of discretion, one needs to compare the position, as I was tiptoeing into, but I'll leave it to your lordships to follow the logic of it. Compare the position where the order stands and compare it if the order, the 6th of December stands. Is there a windfall? No. Compare it with, and then compare it with the position which would pertain if the order is reversed. Now, what one can't do is try to back into some sort of alleged windfall or unfortunate circumstance by starting from the assumption that the order of the 6th of December stands, which is what the judge does. That doesn't lead you to the right conclusion. In other words, the judge takes a wrong path right there. That, in some senses, is not different to the windfall position, but it is a separate strand of that. The third point is that even if I'm wrong about all this, contrary to my vehement opposition, there is some windfall, and that this was, again, contrary to my intention, this is not intended, and contrary to either the spirit or the text of the order. Does that alter the exercise of discretion? Answer, no. No. All the things that the Court of Appeal identified, and that we've identified in our written case, could not tip the balance. We have all the aspects of the delay.
There's basically delay. You say that's the key factor. So we can ignore this change in circumstance.
I'm always reluctant at this stage to...
Well, you haven't mentioned anything else apart from cost orders not being paid.
Well, I mean, it is a key factor. If we're looking at the guarantee, a key factor here will be that this is voluntarily provided by FAAN. In other words, it comes back to the point which we were discussing with my Lord Hodge. They did not need to provide this. So that's another key factor. If you're going to weigh this into consideration, that's a key factor.
President, how did it come that your clients got their hands on the guarantee?
It was sent by counsel for FAAN.
Well, the principal. The principal guarantee.
Sorry. So the actual terms of the guarantee were sent by counsel for FAAN, and then there was a call made on the guarantee, and that
based on the fact that you'd seen its terms.
Yes.
Without actually having the document itself.
Correct. As far as I can see, we got a copy. It was supposed to be sent by Swift, which would give us an electronic version, but it was not sent by Swift. And so what we got was I'll call it a photocopy, but an electronic version sent by email from counsel for FAAN to counsel to AIC on the afternoon of the 6th of December.
Yes, thank you. You'll have to wind up now because I must give Mr. Hussain a right.
Yeah, so if I can just finish, if I may, with coming back to the question put to me, or the proposition put to me by my Lord Hammond, that I'm only relying on delay. Not at all. If one goes back to paragraph 1 of my written case, it encapsulates many of the points that we want to make. It's not delay. They hadn't objected to they, FAAN, had not objected to the making of the word. That's got to be taken. That's a key matter. They could have made an application for adjournment or an extension of time. They didn't make it. There was no mistake. That's recorded by the judge. No one made a mistake. So I mean, delay is a key factor. It is not the only key factor. And so there are many and varied reasons why we say this application needs to be dismissed, both in limine under the structured exercise of discretion, or if it's a general exercise of discretion, in the general exercise of discretion. I'm very sorry for taking up further time than was provided, but if I can assist your lordships, I'm very happy to do so. Otherwise, those are our submissions.
Yes, I take it we consider the question of relief from sanctions simply on your written pleadings.
Yes, and I won't say anything more, but just as I wanted to do, but the Privy Council case needs to be treated with great caution. I think the critical thing is it's a different CPR text. Oh, yes. The wording is different. So it's the case at tab 2 of the authorities. I don't remember offhand the name, but it is Privy Council, and it is the second authority. It's a Trinidad and Tobago case.
Matthews.
Yes, exactly right, my lord. The wording of the CPR is different there, and that's critical. And insofar as other comments were made, it would be about another part, about applications to set aside default judgments. That would be, if that was endorsed, that would be completely contrary to a whole series of English and Welsh cases which take an entirely different approach, which doesn't seem to have been considered by the Privy Council. So I don't think the issue actually critically arises, but I just wanted to make your lordships aware that there is...
You've made the point. Thank you.
You're holding a live grenade in your hand, and just be careful. With that, unless I can assist your lordships further, those are our submissions.
Thank you. Mr. Hussain.
My Lord, if we can go I want to address the point that Lord Sales raised with me as to whether or not the Court of Appeal actually said that the discretion does not arise in this case, or that the judge in this case was not entitled to exercise the real discretion. And to make good that point, if I can take you to paragraph 103 of the judgment, which is in the key documents bundle at 156 and the electronic bundle at 202. It's paragraph 103. It's the last paragraph in Lord Justice Coulson's judgment.
Thank you.
And when he's looking at the application for relief from sanction, and he says, against all of that, of course, the guarantee was eventually produced. in any balancing exercise, that is a strong point in FAAN's favour. But for the reasons that I've explained, I do not consider that it is sufficiently strong to tip the scales in favour of a reconsideration of the second order. And here he's talking about the provision of the guarantee in terms of weight and being included in a balancing exercise, i.e. included in the discretion. In contradistinction to that, when he's looking at it for what we call issue 1 and his principal finding, which you'll find in the key documents bundle at 150, the electronic bundle at 196, paragraph 74, last sentence, I took the court to this earlier, I also consider that she was wrong in principle to permit the reconsideration jurisdiction to be utilised in circumstances where the relevant event, the production of the guarantee, occurred after the order was made and in breach of earlier orders of the court. There was no arguable basis for reconsideration. So Lord Justice Coulson is doing exactly what we say he meant to do in this judgment. He is removing the discretion from the judge on the basis of his first step. And my learned friend asked what I assume was a rhetorical question, that if something doesn't meet Lord Justice Coulson's first question, it can't possibly have any real prospects of success on the second question. But that is contrary to what Lord Justice Coulson himself said. He's saying in paragraph 74 that late compliance cannot be utilised for reconsideration. It cannot form an arguable basis for reconsideration. But when he looks at it as a matter of the balance, he accepts that it is a strong point and has strong weight. So we have to pause to understand the gravity of the error the Court of Appeal has made. It has set up this false binary between applications triggered by the court and by others, and then said that the discretion is removed unless an objective, compelling reason is found, and then further said that late compliance can never be such an objective, compelling reason. So that's the first and important point that I wanted to raise on issue 1. On issue 2, I was asked whether or not the discretion under Riel should have guiding factors. And I can see why this court is concerned with that. We would not oppose this court saying that although there are no rigid fixed categories, the Supreme Court would advise judges to look at the importance of finality and not treat this as any other case management decision. But the fact that I would say for our purpose is that that is certainly not what the judge did in this case. I have already, and I'll go to Ming in a moment, I've already talked about the dangers of dissecting an extempore judgment. We do not have the transcript of the 13th of December. And in my submission, if the respondent is going to argue that the judge didn't consider something properly, it would behove it to provide that transcript. But let's look at what we do have. This is a key documents bundle at 213, electronic bundle at 339.
3.
Electronic 339.
Thank you.
And key documents bundle at 213.
So what is this document?
This is the 13th of December.
Yes, I understand it's the 13th December judgment. Is this what she wrote up after giving her extempore judgment?
No, this is the extempore judgment transcribed. And then she handed...
So we do have a transcript of it?
Yes, and it has a 217, it has an official approval. So it's
I think you were simply making the point that we don't have a transcript for the hearing, so we don't know whether there was any discussion
what exchanges she had
of whether anything was said about how they came to be there or whatever.
And how strongly she quizzed them on finality and all the things that have been discussed. And to be frank, when we were preparing the statement for Greek facts and issues, because myself and my learned friend weren't there, we didn't even know how long the hearing lasted. So we don't know what she said or asked or satisfied herself about finality and other issues. And I urge you not to take this short extempore judgment as somehow suggesting that anything that's not in here was not considered. Be that as it may, what we have in this judgment, if we look at paragraph 17, which is 213 of key documents, 339 of the electronic bundle. She says, in my judgment, the circumstances of the present case are such as to justify reconsideration of the draft order. This is not a case of a mistake having been made or of the court having changed its mind on the basis of the original material. Rather, it is a case in which there has been a significant change in circumstances, in that within some 2 hours of the order being made, FAAN obtained the requisite guarantee. I then refer you to paragraph 18, where she says, and I took you to this before, obtaining the guarantee clearly did involve FAAN because of its parastatal status and having to take a number of steps to obtain all the requisite authorizations from the various Nigerian ministries, as well as the corporation of the Nigerian Central Bank. You are being asked on an appeal to differ from the trial judge and find somehow that my client is the alter ego of these ministries rather than beholden to those ministries, and that those ministries' dilatory behaviour can somehow be attributed to my client. And we say that is not a safe assumption to make. It is not an appropriate assumption for you to make on appeal. Then at paragraph 23, bless you.
Thank you.
She talks again about the efforts made in December. Paragraph 25, she talks about finality, and we've looked at this. Paragraph 29, she says, it seems to me, and Lord Hodge talked about this, it seems to me that whilst FAAN's evidence has not been as comprehensive as a court would wish to see, and there are matters that certainly ought to have been better explained, for instance, why CBN does not appear to have been approached until as late as the 2nd of December, as well as the involvement of the different third-party banks. It seems to me that on balance, and looking at the evidence as a whole, FAAN has provided sufficient as well as good reason for the delays. She then talks again about the parastatal status, and she talks about bona fide efforts having been made. These are not factual points in my submission that you can appropriately disagree with as an appellate court. And then I want to read out 32, which I didn't earlier. This is over the page. It's 216 of the key documents bundle, and I don't know if you have it on the electronic. It's
No.
342. Paragraph 32. Lastly, I must evaluate all the circumstances of the case to enable me to deal justly with the application. Militating against my exercising my discretion in favour of FAAN is the fact that litigation should be conducted efficiently and at proportionate cost, and the court's orders are made to be obeyed. This is again a reference to finality. That's a second express reference to the importance of finality in this judgment. This is not a judge acting in an untrammelled or cavalier manner.
Well, I mean, it might be observed that she doesn't call attention there to the fact that there's been a trial, that this is finality in the context of a final order made after trial.
Sorry, my lord, what are you referring to as a trial? Are you talking about the application for relief from sanction?
No, the application for the order for enforcement of the arbitral award.
The 6th of December trial, yes, and she does mention that, my lord. To be fair, I mean, she's talking about the fact that she heard the parties on the 6th of December. She notes that the points that were made to her could not have included the fact of the guarantee. It may be, Lord Sales, that you are uncomfortable that she hasn't said out loud, I acknowledge that there has been a trial, but that may be a justified concern.
Well, I mean, the concern that I'm putting to you is similar to the one that I was putting to you before on paragraph 25. It's really whether she has faced up to the significance of finality in this particular context, because the points that she makes here look like, I can put it this way, fairly standard case management type issues, well, yeah, rather than finality after a full set-piece hearing, as the 6th of December was supposed to be.
I take your point. In an ideal world, maybe she could have worded it differently, but in my submission, you would be falling into what the appellate courts are told not to do, which is to dissect the language used to find fault. And this is an extemporary judgment, given the transcript which we do not have, and it's given under some time pressure because of the call on the bond. But paragraph 32 is important because she does again talk about the need for court orders to be obeyed. And if that's not good enough, so then, my lord, then I'm afraid that we are then really falling into dissection in my submission.
It's a fair point that you make.
The last point that I want to look at is this one. The judge looked at all the letters to the various ministries. She saw the evidence that there was. My learned friend cannot say properly in my submission that FAAN somehow, contrary to the evidence the judge accepted, was able to get its own funds. It gave evidence, sworn evidence, that it has no account of its own and it needs help from these ministries. I take Lord Hodges' point that he personally feels disquiet seeing the tone and the dates and the regularity of the correspondence, but I would say that it is particularly dangerous and not appropriate for an appeal court to be taking a view of the correspondence different from what the judge did, or to find, well, you're welcome to do that, but that's not really the test. The test is whether you find the judge's view, both on the reasons for the delay and the weight of the delay, as being irrational or outside the scope of her discretion. And in my strong submission, you do not have the basis to do that properly. I can say this, pulling rank as the only person not of Anglo-Saxon origin in this speaking to you today, that when I read these documents, I immediately understood the hierarchy, the civility, and the process of writing to superiors. And it's not always the case that people write letters without speaking to someone saying, I'm going to send you this letter. So the fact that an English person or an English civil servant would be writing frantic letters to Priti Patel or whoever the minister is not the test here. And it's particularly dangerous when looking at a convention award which would come from Azerbaijan to Australia to say, well, we think something is not right with what the trial judge has found. And I really would say that if there were a case for bearing in mind the importance of respecting the exercise of judicial discretion, this careful judgment is one such case. My junior has reminded me that as a matter of good procedure, I have to say before the hearing finishes that we would ask that arguments as to costs be left over till the judgment.
That is what we do.
Okay,
You don't need to make a formal application.
That is very useful. If I ever come back, I'll remember that. The only other thing I would say is, my Lord, is just please avoid this. What's happened is that the respondent, I say this respectfully, has tried to work backwards and make you approve the Court of Appeal's exercise of the discretion. But that is not the question. The question is, was the Court of Appeal entitled to re-exercise the discretion?
That's appreciated.
Unless I can assist you further.
No. Well, the court is grateful to counsel for their assistance in this matter. I think it is appropriate at the close of play to make one observation, and I adverted to it indirectly at the outset, which was the need for brevity. And parties have produced full written cases, and in one one party has produced a written case of 50 pages, together with very detailed footnotes, which contain not just references but argumentation, which means that in substance they are considerably exceeding the guidelines laid down by this court. There is, as a word of warning, there is a material risk that the court will not accept such documents in future. So I hope parties will bear that in mind, because it's also, it's exceeding the limits which this court sets down, and B, there's a danger if there are serious arguments that are being tucked away in a footnote, the court might not appreciate their significance when preparing for the appeal. So I hope that parties will bear that in mind. Thank you very much. The court will now adjourn.